afternoon. Please be seated. Welcome to the 14th Court of Appeals. This afternoon we have two cases on the docket. The first case is 14-22-00934 MI LLC versus California Resources Corporation. Our
counsel for MI LLC, John Robert Clark.
Okay.
Counsel for California Resources Corporation, John Hoffman.
Thank you. And have you reserved time for rebuttal?
Yes, Your Honor.
All right. And then our second case on the docket is 14-23-00109 Galveston County versus Brent Cooley. Are parties here?
Yes, David Hutchinson on behalf of David Mensis for the county appellant.
Thank you. And have you reserved time for rebuttal also? Okay. Have you let them know how much time you'd like to reserve? All right. Counsel for the first case, we are ready to proceed whenever you are.
And by the way, this is the first time I've ever had somebody use the screen. So.
Me too.
Well, Your Honor, we had a little bit of a technical issue with this. My tech people recommended one solution to black out the screen between items, and unfortunately, IT people here said that wouldn't work. So unfortunately, you're going to be seeing just a balloon in between the exhibits, if that's all right with you. As soon as I can get my password in. Proceed, John?
Yes.
Good afternoon, Your Honors, and may it please the Court. My name is Robert Lombardi, counsel for MI LLC. This is an appeal of a declaratory judgment action MI filed against CRC to define the party's duties under a Texas contract. The trial court dismissed that action, finding it lacked personal jurisdiction over CRC. As background, CRC was sued in a class action in California State Court by the employee of a third party unrelated to MI. The plaintiff alleged CRC was his employer and violated California wage and hour laws. Some of the members of the class action were provided to CRC by MI. So CRC impleaded MI into the California action seeking indemnification. CRC's claim against MI is based on a Master Services Agreement, or MSA, between CRC and MI that includes A, mutual indemnity obligations, B, a provision that MI obey all government regulations, and C, choice of law and venue provisions, which state that issues regarding the MSA will be decided under Texas law and in the state or federal law in the state of Texas. Based on the above, MI filed its declaratory action in this Texas District Court seeking to have the contract interpreted under Texas law. This is a separate action from the California lawsuit and only seeks interpretation of the MSA. CRC objected on the basis of personal jurisdiction, and the trial court found in its favor. CRC's argument, which was accepted by the district court, is that the Texas filing arises out of services provided by MI, and as such, falls under the commercial terms, a subordinate agreement defining specific products and services for the California market, under which disputes must be litigated in a California court under California law. That argument has no merit. This matter is controlled and decided by 4 sections of the MSA. The first section, and I will bring it up on the screen, is section 1.2, which says in the event of a conflict between the agreement, meaning the MSA, and any individual commercial terms, the provision of the agreement, the MSA, control. The MSA is an umbrella document, and its terms supersede any commercial term. It is the engine that drives the train. CRC, by arguing the commercial terms control, is essentially trying to have the caboose pull the train in the opposite direction. The second MSA provision, which is section 11, Compliance with laws. That requires that the contractor warrant that it will comply with all government regulations. That is the alleged contract violation upon which CRC bases its indemnity claim. This again is an MSA term. It's an umbrella term that applies to all dealings between CRC and MI under the MSA. There are no similar terms under the commercial term. The third section is, excuse me. The third provision is section 12, the indemnity section. And within the indemnity section, sections 12.2 and 12.3 contain mutual indemnity provisions for actions arising out of or relating to the agreement. CR says this includes the alleged breach, MSA breach, of the requirement to obey all regulations. Again, these are umbrella terms under the MSA, not the commercial terms. There are no indemnification terms or provisions in the commercial terms. The last section is section 19. Which is the choice of law provision. Section 19.1 specifically provides that the laws of the state of Texas shall govern this agreement, meaning the MSA, and the parties voluntarily submit to the jurisdiction and venue of federal or state courts in the state of Texas. Section 19.2, upon which CRC relies, contains a carve-out limited to disputes arising under the commercial terms. As I previously stated, there are no indemnity clauses under the commercial terms agreement. The services and products identified in the commercial terms all relate to drilling fluids or drilling operations. MI is a company that specializes in providing products and services related to drilling fluids. It is not an insurance company selling indemnity services to customers. CRC attempts to recast its indemnity claim as something arising out of the services, and that does not correspond to the reality. Further, the actual complaint in this matter does not touch or even mention the commercial terms or the California litigation. The plaintiff is the master of the complaint and defines what is covered by the complaint. It just asks for an interpretation of the MSA under Texas law. That is something that clearly falls under section 19.1 and belongs in a Texas court. When a party agrees to a choice of law provision, even if permissive, the party has accepted personal jurisdiction or has waived any opposition to personal jurisdiction. Thus, the court need to look no further than the explicit terms of the MSA. If the court still had any doubt, the court need only look at the next exhibit. This is the indemnity letter that CRC sent to MI demanding indemnification in the California action. As you can see in the last paragraph, it states it states the MSA, which is enclosed, includes several indemnity provisions relevant here. It then lists the specific MSA indemnity provisions it believes applies to its request for indemnity. It contains absolutely zero references to the commercial terms or any language within the commercial terms. This is a matter arising out of the MSA and is subject to section 19.1. It requires the applications of the law of Texas and agrees to a venue in Texas.
Could you explain why you're arguing that this arises out of the MSA and not the commercial terms? The difference between 19.1 and point 2?
Yes, Your Honor. 19.1, and I will go back to it, Your Honor. It states that well, first of all, it states that maritime law applies, but then it says if it does not apply, the application of the choice of law rules, the parties voluntarily submit to the jurisdiction and before I get there, sorry, Your Honor. Without the application of choice of law rules, Otherwise, the laws of the state of Texas shall govern this agreement period. So.
But California could apply Texas law like we could apply California law in a contract provision, and that's not the issue we're here over.
It certainly could, Your Honor, but the very next sentence says that the parties voluntarily submit to the jurisdiction and venue of federal or state courts of the state of Texas.
What
And
does
therefore
it mean?
they've consented
What does
to
it mean to submit? What does the word submit mean in this paragraph?
It means to place yourself before, to appear before.
So how is commercial, in this particular agreement, and are we construing commercial terms as plain and ordinary meaning of those words, or is it defined in this contract?
Your Honor, the commercial terms is a separate document that has been incorporated as part of the overall agreement.
Right, but so your argument is that those terms and only those terms are the limit of that subset?
Yes, Your Honor, and that
Okay.
makes perfect sense because those are the activities that are actually limited to California. Everything else is part of an MSA applying across all of North America. And therefore, the parties agreed that the law of the state of Texas would define any issues out of the MSA, which is a multi-state and actually multi-country agreement. And continuing on, Your Honor, as I've already stated, CRC consented to Texas venue waives any personal jurisdiction argument. Even if CRC had not consented, the facts establish that CRC has a significant contacts with the state of Texas relevant to the MSA. And in fact, as their own declaration shows, they have been part of the contract for 8 years and have engaged in over $1 million worth of services under the terms of that contract. And in addition, they have a registered agent in the state of Texas. They made a demand for indemnity in the state of Texas. So we have an ongoing relationship, a contract that calls specifically for the application of Texas law. And all those actions must be looked at together in deciding if they have purposely availed themselves of the ability to conduct activities in the state of Texas and reasonably foresaw being held in the court in the state of Texas, which is clearly here as it's been a 10-year relationship with constant dealings back and forth. And in fact, the demand made into the state of Texas. Your Honor, my time's up. I would like to reserve my remaining time for rebuttal, if there's no further questions.
Thank you.
Thank you.
And I'll start off just, we're not really here, I think, generally talking about whether there's minimum contact somewhere. We're talking about the contractual, what are the parties contracted to? And is that subset of the commercial terms completely walled off to that part, or is there any bleed over?
Thank you, Your Honor. May it please the Court, John Hawk for California Resources Corporation. As I begin, I would like to thank the Court and its staff for quickly processing our substitution of counsels. I just changed firms last week, and I apologize for the short notice, but it is appreciated that it was processed quickly, including the Pro Hoc Vice application. As to the contract itself, as Mr. Lombardi noted, there is one agreement. The Master Services Agreement and the commercial terms are separate titled documents, but they are one agreement, and they do work together, and they do incorporate each other by reference. And there are several places in the agreements that I would like to point to where they do that. The Master Services Agreement on the first page defines the term agreement as being the MSA and the commercial terms. On the first page, the Master Service Agreement goes on to say that it will include all of the exhibits referenced thereto, and the table of exhibits on page 2 includes the commercial terms. On page 2 of the MSA, which is page 168 in the record, it states in section 1.1, any commercial terms agreed to by the parties shall incorporate this agreement, whether mentioned or not. The commercial terms likewise do something similar, where they mention that they incorporate the Master Services Agreement through the exhibits listed in the commercial terms, and that's on pages 1 and 2 of the commercial terms. What MI would have this court do is artificially separate the two documents simply because they're two documents, and in the process of doing that, render inoperative all of these provisions which say they are one agreement and they must be read together. It would also render inoperative the structure that the master services agreement sets up between some of the provisions that were just pointed to. A couple points for background which I think are important to understand the structure. The underlying California action, which is referenced in the original complaint on the record at pages 6 through 10 through numerous paragraphs and throughout as what is underlying MI's action here. What is happening in the California action, as plaintiffs allege, is that MI hired and classified what are referred to as mudmen and provided those mudmen to California Resources Corp drilling sites in California. Plaintiffs allege they were misclassified and sues California Resources Corp as a joint employer under California law. That provision of mudmen is a service under the MSA in commercial terms as they comprise a single contract. We've cited a number of provisions in our brief to the court showing that the exhibits to the commercial terms, which include the MSA, show billing rates for drilling fluid engineers, which is another word for mudmen, and goes on to specify the requirements for drilling fluid engineers. They were provided as a service under the overall agreement. And those services are defined in the commercial terms under section 1.2 as not only the services and the work, but the duties and the obligations of MI thereunder. And so the provision of services cannot be narrowly cabined to something like who paid them and were they properly paid. It is the overall relationship of the parties under this singular agreement as to were they provided, were they properly classified, were they properly paid.
And let me just ask you a more general question. I'm trying to figure out what the court can draft that would be applicable to the next case that comes before it, because obviously we've got two different clauses here that talk about where things are going to be litigated. We have the general provision and we have a specific provision. So we're in California for the general and we're in Texas for the specific, the commercial terms, right? But I'm just saying, how far do the limits of these things go? Because obviously you have to have a class of things that are going to go into the general provision and then a class of things that are going to go into the specific that are not arguable, and then you get the stuff in between that we're in the weeds.
Thank you, Your Honor. I would argue that the section 19.1 is the general provision, which provides for general jurisdiction in the state of Texas as not a mandatory, but a permissive choice of form clause and Texas law. That is the general. And then section
as long as we're talking about the commercial terms, right?
I would say the overall agreement, because the commercial terms incorporate by reference the MSA.
Okay.
So as I read these contracts, and I believe is the proper reading, so as not to read inoperative all these provisions that say the MSA includes the commercial terms and the commercial terms include the MSA, they are one agreement, despite having separate titles. And that's under the structure of the MSA providing overall obligations, and the commercial terms then saying, in this case, you are going to provide mudmen to these CRC sites in California. Back to your question, Your Honor. Section 19.1 is the general provision. Section 19.2 starts notwithstanding section 19.1. So I believe that is the more specific provision that then carves out in a very thought out way the structure for how to deal with lawsuits arising from and relating to services provided by MI to CRC under this agreement, which is, if we look at 19.2, it includes a number of Romanettes. The first one deals with services provided by MI to CRC in California and says that disputes for those services shall be heard under California law in California and Kern County, which is where the lawsuit that is underlying this is pending. The other Romanettes go on to set up a structure that shows that the parties intended that if they provided services in other states, then disputes arising from those services would then be heard in those states. Romanette 2, for example, says that disputes regarding services provided in the state of Texas shall be heard in the state of Texas under Texas law. Romanette 3 does the same for Oklahoma for services provided in Oklahoma. And Romanette 4 for Kansas, Romanette 5 for New Mexico, and says anything beyond that, parties need to agree to the law. So as to your question about how to do this so that there is no tension, I don't believe there's any tension in how this is set up, which is generally disputes should be heard in Texas under Texas law. However, for services that are provided by MI to CRC in any of these states that are specified, then 19.2 is a specific carve-out that says the parties must have their disputes heard there and must have those disputes heard under the laws of those states. And I think there's absolute consistency between those, and that is how this agreement is intended to be. That is because those states have a closer connection to the services that are provided there.
So if we were to look at choice of laws, whether California law or Texas law applies, does that make a difference as to where these cases will be decided?
The provisions in 19.2 provide for both the law of the state and the form of the state where the services are provided.
Does that have to do with venue? Applicable law versus venue versus jurisdiction. Can you make a distinction between those three? So let's start with number one. Does a choice of law determine where the case has to be decided?
In this case, no, because the contract says, apologies.
So now, 19.1 talks about submit. Both parties submit to Texas jurisdiction. That is in persona jurisdiction, is that correct? In other words, both parties agree to submit to Texas jurisdiction.
I believe that is a fair read of it, subject
Okay,
to 19.2.
but venue is a different matter. And so venue is decided by 19.2. Is that the way you read that?
I don't, because I believe that creates tension in between the provisions where 19.2 is mandatory and 19.1 is permissive.
Mandatory as to what? As to choice of law?
And I believe as to where the lawsuit needs to be brought.
Venue, thank
Venue.
you. Okay, so we're talking about venue, where the case must be decided. Does 19.2 specifically state Texas as the venue? 19.1, pardon me.
Not as mandatory. It says voluntarily.
In fact, does it even say venue in Texas?
It does not. It says
It
jurisdiction.
says
of Texas.
submit to the jurisdiction of Texas. Does 19.2 say the word venue?
Jurisdiction and venue. Yes, it does.
Jurisdiction and venue. So, thinking in terms of venue, where must these cases be decided?
Kern County, California.
Is that what 19.2 says?
For disputes regarding services provided in California, yes, it says the jurisdiction and venue of the courts of Kern County for the adjudication of their liabilities and responsibilities thereunder.
Okay.
So, Your Honors, we believe that the trial court correctly found that there was no consent to CRC, California Resources Corp, being brought into Texas to defend this. We showed that in the trial court. We believe the trial court correctly found as much. And then we also went on, as reflected in the trial court's order, to address the other alleged bases for jurisdiction over CRC.
Well, remember, we talked about jurisdiction over, and that's in persona jurisdiction. Isn't that decided by 19.1 that both parties submit to the jurisdiction of Texas?
Yes, but we still need minimum contacts, Your Honor.
Is that not minimum contact to submit to the jurisdiction?
I don't believe it is, Your Honor. There are, as shown in our papers, there are very few contacts that we believe qualify for purposes here for a Texas court to exercise jurisdiction over California Resources Corp. Because, in part, we did not intend that for a dispute like this, that we would be submitting to jurisdiction in Texas.
Okay.
And the example we gave in our appellate brief was for something not regarding services provided in California. So if there were a dispute about some misuse of, say, California Resources Corporation's intellectual property by MI that fell outside of the carve-out in Section 19.2, then perhaps, depending on the circumstances of the case, 19.1 could apply. And under that circumstance, it may be said that we voluntarily submitted to Texas jurisdiction. But those aren't the circumstances here. In this contract, we don't believe is a voluntary submission to Texas jurisdiction based on the nature and the specific circumstances of this dispute. So, moving on briefly to the other bases that MI has argued, we don't believe any of them are legally sufficient, and we showed so in our papers. There's case law that we cited that having a registered agent is not enough, that contracting with a Texas company is not enough, that paying a Texas company is not enough, Those are all cases that we cited in our brief, and we understand MI's argument that they want to compile the quantum of contacts and say that those are sufficient. But the case law, including the Montepulo case that we cited, show that it's not just adding up all the contacts, the quality of the contacts have to be taken into account. And what we have here is there simply is no basis for general jurisdiction. Having a registered agent filing in a separate case for insolvency in Texas is legally insufficient. And as to specific jurisdiction, the circumstances underlying this case have nothing to do with CRC's contact with Texas. This case pertains to services provided in California, individuals performing work in California, a lawsuit in California for which we're seeking indemnification, which again is under the commercial terms because it incorporates the MSA. So we believe the trial court's ruling is entirely correct on all bases, and we respectfully request that the court uphold the trial court's opinion.
Thank you.
Thank you, Your Honor.
Thank you, Your Honors. And in rebuttal, I'd like to begin by, Mr. Hawk pointed out that the agreement does, or the MSA does refer to the commercial terms and the MSA forming one agreement. But it also repeatedly distinguishes between the MSA itself and the commercial terms in which it describes itself as the agreement. For example, in 1.2, which I put up on the board, in the event of a contract between this agreement and any individual commercial term, so it's drawing a distinction between the two. Or in 1.5, this agreement together with any commercial terms embodies. So when you are reading agreement within the commercial term, you have to look at the context in which it is being used, because it is being used interchangeably. I believe Mr. Hawk made an error in terms of talking about section 19.1. And that is that section 19.1, the parties do agree to submit to both the jurisdiction and venue of federal and state courts in Texas. So that is equally on the board. There's clearly a consent to the venue within the state of Texas. I would also like to point out something else that he drew up as an interesting distinction. The fact that within section 19.2, he identified different commercial terms that were already contemplated by the MSA, and he demonstrated how each of the commercial terms would have local laws applying to it. The California commercial terms would have California laws applying. Oklahoma would have Oklahoma. Texas would have Texas. Now, what we're arguing about today is not the provision of any service. The action in California is an action in which the plaintiffs are calling CRC their employer, and they're saying their employer violated California wage and hour law. And CRC is coming to MI for indemnification. Indemnification is purely an MSA term. And if you accept Mr. Hawk's explanation, the MSA term of indemnification could be subject to 4 different interpretations under 4 different states' laws with potentially different results. That is obviously not something that the parties contemplated when they drew up this contract. They wanted one unified umbrella document, then individual contracts providing specific terms relevant only to the activities in their state. Indemnification is not an activity related only to the state of California. It's a universal term. It should have universal application across all of the commercial terms. And per the contract, the parties agreed that that was a Texas law in a Texas venue. And that's the distinction here, Your Honor. This case is not about the underlying California claim. That is something that is against CRC. MI is not even a part, MI LLC is not even a party to the underlying litigation. There's no claims against MI. in the underlying litigation.
Let me ask you a question. And there's lots of moving parts of this case that make it a law professor's dream in a lot of ways. Could you not have drafted the contract to where the definition of what the contract says is controlled by one state's law? So regardless of where you go to, you're stuck with the definition of what that term means from a specific state. So you get yourself out of the problem of saying, well, we're here, and people are going to say that.
Your Honor, in hindsight, that's a wonderful suggestion. Unfortunately, we're in the position where they felt it would be better to have a universal agreement governing all of the commercial terms. And then, based upon markets, based upon, for example, in Louisiana, there may be a provision regarding how you treat workers' compensation that may require separate language from what you would normally use if you were in California. They decided for those purely local matters. And this is not about how MI even paid its own people. This is just only about whether or not MI owes indemnification. And that's the only thing we're looking for the declaratory judgment on. And that's clearly within the MSA. And because of that, should be governed by Texas law and in a Texas venue. Thank you.
Thank you, counsel. Cause number 14-22-00934 ZV MI LLC versus California Resources Corporation is submitted. Counsel is excused, and I guess we'll reset for the next case.
Thank you, Your Honor.
Thank you.
We can proceed whenever you're ready.
May it please the court. My name is David Mensis. I represent Galveston County, Texas. The trial court in this case lacked jurisdiction for 3 independent reasons. There are conditions precedent, statutory prerequisites for jurisdiction in a TCHRA case against a governmental entity. One of those is that the employee charging party plaintiff must file a charge of discrimination within 180 days after the latest of the alleged discrimination. That did not occur here. The second is that even if the charge is timely, that employee needs to establish the existence of a prima facie case, much like in an ordinary summary judgment. That did not happen here either. The third issue that I think can be even outcome determinative here is that we have a brief with no citations to the record. And that means that the only evidence that can be considered are the facts that we put into the record, which, by the way, was the only evidence in the record at the trial court level as well. And so those facts are what the court must consider in deciding whether jurisdiction exists. And those facts allow the court to decide that it doesn't as a matter of law. I would like to start kind of in reverse order, first with the 38.1 issue. It's not a complicated one. We should not collectively have to dig for the other side's evidence. I would submit that there isn't any, even if there were record sites that would support the existence of jurisdiction, but at a minimum there needed to be a citation to some evidence, and there was none. That is consistent with the general approach of also not citing to the seminal cases, to the Supreme Court cases going all the way back 43 years, to the Ricks case, which tell us why these same arguments made here by the appellee have been rejected for 4 decades. And so the waiver issue matters to all of that, because where's the evidence to say that this case is any different than those other cases in which the same argument was rejected? Now, as to the charge, in a visceral reaction way, it might seem logical to say, well, hold on a second. If my termination happens less than 180 days before I file my charge, it should be timely, right? But that's not the law. The law looks not to when something takes effect, but when the employee first is aware of discrimination, when specific facts exist to put him or her on notice that his rights may have been violated. And that's why Cooley's testimony matters here. Because in his deposition, I asked him, when we were talking about the key events in the summer, all more than 180 days before the charge was filed, well, did you think this was discrimination? Did you think this would? Did you think that was? Unequivocally, as to each untimely incident, yes, yes, and yes. And so the latest of those incidents happens August 6th, when the school superintendent of the district to which he was assigned says, we want him out. That's 194 days before Cooley says he filed his charge. It's 204 days before the EEOC gets it. He then, faced with termination, asks for FMLA leave. He gets it. Comes back. After several rounds of internal affairs grievance procedures say, we recommend termination, we recommend termination, we final recommend termination. Cooley goes on FMLA leave. He comes back. Sheriff Trossett says, I see no reason not to do exactly what the Internal Affairs Committee said to do, and that's terminate the employment. Now, there's been some argument that somehow this differs from the cases we cite. Ricks, Morgan, specialty retailers, all of which squarely address this exact issue. But there's never anything granular to tell us how it's different. In fact, there's not even a mention of any of those cases. So what we're left with is those opinions, where in Morgan, for example, the court says you can't take a termination and use it to save a charge that wasn't timely filed after the alleged discrimination occurred. It doesn't work, and it doesn't matter if they're related. Both of those come from Morgan, and both of those also appear in Ricks. Specialty retailers in 1996 really just reaffirmed what Ricks said, and so you see it in all kinds of settings. You see it where there are grievance procedures, and you see it where there are not grievance procedures. It's a common mistake to rely on the date of the termination, and it's the mistake that Cooley made here. Assuming there had been a timely charge, the prima facie case is doomed for different reasons. And that is the key way to make a prima facie case if you do not have direct evidence, and here there's neither direct evidence nor even a suggestion that there is direct evidence. When you don't have that and you have to make your case circumstantially, it's the well-settled, got to compare yourself to somebody similarly situated. The law tells us what that is. It tells us that it's somebody who has essentially the same job, same supervisor, same division, same department, in this case, same rank, but most critically, somebody whose conduct was nearly identical. And what we have here is a really unfortunate situation. You have a police officer who at one time was lionized as one of the heroes for going out and getting the shooter out of that Santa Fe school. But 2 years later, goes to a bar, closes the bar down, gets really drunk, and when a female black police officer comes to take him home, pushes her a bunch of times and calls her the N-word. That's undisputed. He says he can't remember, but the entire investigative file includes witnesses that saw it. And so when I asked him in his deposition if you're aware of anybody else who's done that, the answer was no. There was a faint-hearted attempt to compare himself to about 10 other people, but we walked through them one by one by one. And there's a chart in the brief that shows why each is completely distinct, not for one reason, typically for 4 or 5. And so he kind of gave up on all but one, and that's this Sergeant Roy. But Sergeant Roy, if everything Cooley says is taken as true, once said, refer to somebody as boy. And the law says that's not close enough. And that's separate from the fact that Sergeant Roy had a different job, different supervisor, did not work in the school division. So everything is distinct. So absent a prima facie case, Unlike in a private actor situation, where that would just be a summary judgment issue, that's a jurisdictional issue. That's a condition preceding to jurisdiction. If that condition is not met, much like the charge, there's no waiver of immunity. And that's what we have here. We have immunity for both of those reasons. The retaliation claim also fails to invoke the court's jurisdiction for separate independent reasons. Again, there's no prima facie case, but here it's a little bit different. Here, in order for there to be a prima facie case, there had to be protected activity. And under the state version, the state equivalent of Title VII, the TCHRA, that needs to be one of two things. Either he's complaining about something discriminatory, which he says he never did, or he's seeking to take a benefit provided by the statute. In this instance, it would be a reasonable accommodation. He says he never asked for one. And so what happened at the trial court level is he said, well, hold on a second. I sought FMLA leave under the Family and Medical Act. Well, that's a different statute. It's a federal statute with a different aim. Under the FMLA, you're showing to your employer, I cannot work. I need up to 12 weeks off because I can't work. The ADA is very different. The ADA says, I can work. Help me do it. Get me a special chair. Get me a special desk. Let me take breaks and watch me do my job. And so we cite the Acker case to explain that a request for FMLA leave cannot be an example of protected activity. That's been decided. And so what happens is he sort of tries to pivot away and come up with some other protected activity, but the evidence isn't there, and the record citations to that evidence aren't there either. So once again, we have a prima facie case not existing. No prima facie case means no jurisdiction. And you know, this is an important case, both factually and legally. It's factually important because it touches on the county's ability to do the right thing in a really difficult situation. And it's legally significant because it tacitly urges the court to depart from 40 years of law. And the twisted irony of it is that the real victim here was in a protected class. The real victim here was someone the law aims to protect in these situations. It wasn't Cooley. And unfortunate as it may be, his own misconduct is what cost him the job. And that misconduct is never protected by any statute, even if it's related to his disability. That too is settled law, and I will reserve my remaining 5 minutes for rebuttal.
May it please the court, Eddie Hodges Jr. on behalf of the appellee, Mr. Frank Cooley. We're here today after the trial court properly denied the defendants or the appellants a motion for summary judgment and also pleaded jurisdiction. In the trial court setting, the trial court found that the plaintiff had established his prima facie case of disability discrimination and retaliation under the Texas Labor Code. The appellant here today has established 3 issues in which we will address here at the court today. The first issue is whether the Texas Labor Court applied, given that the EEOC charge was filed in February 2021, and the last act of discrimination was December 16th of 2020. The second issue is regards to the prima facie issue, and the third issue is the no citation on record brief that brought up here today. As it relates to the third issue, we assert that our brief did comply with that, and asserting that we established the evidence that was established at the trial court level was also indicated in the briefing that followed. As it relates to the first issue as to the 180 days, the issue here is that the plaintiff was given notice on August 6th that he was may be terminated. On August 6th, he was actually given a notice that his position was being eliminated from the school. So he worked as a liaison for a school district, Texas City. So he was given notice that his position was being eliminated. And at that point, he was demoted from lieutenant to deputy. Thereafter, he took FMLA leave from August to November of 2020. During that time on FMLA leave, he did not have an expectation that his employment had ended. He did not know that
he knew beforehand that they had recommended his termination. Is that right?
he knew that they recommended him to go through this process, but he did not know that it was going to lead to a termination. He also had FMLA that he wanted to take, and that he was already in motion of taking prior to that decision being taken. And so it was his understanding that being on FMLA is that he was still an employee at Galveston County.
Ms. Ray, go ahead.
Oh, I was gonna say, maybe I'm remembering the deposition incorrectly, but I thought he testified at his deposition that he knew that they were recommending that he be terminated at that point.
Yes, he understood that there was a process that was going to be undertaken for his termination that was ongoing, that was starting, but he did not know at that time that that was going to lead to his termination, which he ended up coming back from FMLA leave in November, and then there was a time period of maybe a month and a half in where he was still in that position upon coming back until he received the final notice of his termination after on December 16th.
It seems, pardon me, I love the plants this time of year. You're not suggesting that the FMLA somehow tolls the time period?
No, Your Honor, I'm not suggesting that it tolls the time period. What I'm suggesting is that the client, or excuse me, the plaintiff did not know that he was being terminated until he was actually being terminated. Now, when he was on FMLA leave, he believed that he was still an employee working within Galveston County, and that his position was from lieutenant to deputy. And so when he returned from FMLA leave, it was the same belief that he had up until the termination notice that he received.
But is the date that we're supposed to look at the date at which he knew there could be an adverse outcome, or is it from the date of termination?
It's from the date that the individual believed that the discrimination action occurred, and so the last date of discrimination action was on December 16th when he realized.
But that sentence is implying two different things. If you're saying the date that he knew it would have occurred, and then the last date that it happened. So which date should we be looking at?
The last date that it occurred.
Do you have a case to support that?
I don't have the case site on hand, but I know that there's a case. I don't have it up in front of me, but it looks at the date in which of course the 180 days starts when the last date of discrimination action. That's the statute in the Texas Labor Code, that 180 days after the last discrimination act. And so here is being argued that he had notice of a potential termination, recommendation of termination prior to the 180 days, and that should take to an effect to when the 180-day clock starts. But in essence, we're arguing that the 180-day clock didn't start until he actually received the actual termination, because at that point, before that point, he was in that role of a demotion versus actual termination. So once the recommendation for termination, that became the last act of discrimination. So in that argument, we assert that the last act of discrimination occurred within the 180 days, and so that his EEOC charge was timely filed, and that's what the trial court, we can infer that there's no finding of facts from the trial court, but we can infer that that's what they found as well, that the charge was timely filed. And so going into the last issue, the second issue in which the appellants have addressed here today relates to the promulgation case of discrimination and retaliation under the Texas Labor Code. So the appellants are correct that the appellee has filed a claim for disability discrimination and retaliation in the Texas Labor Code. The appellee was once a renowned police officer in Galveston County that led the arrest of the school shooter at the Santa Fe shooting. He was named Officer of the Year, so his qualifications within that respect of the prima facie case is pretty well known that he was qualified in that position. He also has a qualifying disability as PTSD. He gave notice to his supervisor and his managers that he had PTSD, and in that notice, it was assumed or inferred from him that some type of accommodation would then there follow.
Did he request an accommodation?
He did not outright say I want an accommodation, but his testimony was that it should have been inferred from his language of giving notice of his PTSD that he may need some help, which the case statutes, case law has specifically said that it doesn't have to be verbatim saying, hey, I want accommodations, but it can also be inferred that accommodations were being asked for based on his giving notice of his PTSD at that time.
So does the case law, I'm sorry.
Okay.
Does the case law state that giving notice is sufficient to infer that he's requesting an accommodation?
Say that again?
Is the case law saying that giving notice of his PTSD, is that sufficient to infer that he's requesting an accommodation? Just telling them that he has PTSD, is that enough for a court to infer that he's requesting an accommodation?
I think there's probably more circumstances that, or more facts that need to be included than that, than just say, hey, I have PTSD. I think that the facts that there should have been contact with the HR and moving forward and setting him up with that position to have that conversation would have been the next expectation. That's what his reasonable expectation was, is that that's what would occur thereafter. And so once he gave notice, he would assume that the company, or excuse me, Galveston County would do something in regards to that notice. So there's more of a give notice and then an action in return from that notice. And so with that, going into the prima facie case and the evidence that we've established that the plaintiff was had a qualified disability. He was qualified in his position. He suffered an adverse employment action when he was recommended for his termination in December 2020, and that there was disparate treatment in this case. And that disparate treatment has been highlighted here is that the conduct in which they stated that is only unique to Mr. or the appellee, Mr. Cooley. The statutes, or excuse me, the case law states that the conduct doesn't have to be identical, but it has to be similar or in a similar manner. And so here we have asserted that Mr. Cooley has given notice of other individuals in the department who have used the same racial vernacular, using the same conduct, and even his own supervisor using the same racial vernacular around kind of the office space as well. So with that, there was no investigation that was done to any other individuals who used that same language, and so he believed that he was being targeted. Months after that, he gave notice that he had PTSD and that he was undergoing some mental health issues. And so with that, we believe that there's a correlation between, and the trial court did properly find that there was a correlation between his adverse employment action and then his disability, given that other individuals who were non-disabled were treated more favorably and were not investigated by using the same racial vernacular and language that was commonly used in the workplace. And so he believed that he was being targeted and that his protected class put him in that category to be terminated. And then lastly, as it relates to retaliation, the protected activity we've asserted is that he could give notice of his PTSD to a supervisor with the expectation of some type of recourse or some type of remedy to be available to him thereafter. And then thereafter, after his protected activity, he was there terminated and was terminated thereafter. So we assert that there was a causal connection between the termination and his protected activity based on the fact that the plaintiff, or the appellee, had recently given notice of his PTSD and that it was actually brought up as to part of the reason, not part of the reason why he was terminated, but it was inferred as to the reason why he was terminated based on the disparate treatment. And so that goes into what the trial court found is that there was more than a scintilla of evidence to show that the prima facie case has been met, and that left the burden up to the defendant, or the appellant in this case, to establish a legitimate business reason as to why he was terminated. And so the legitimate reason is the misconduct in which they've established, and then in return, the pretextual pretext that we've established through evidence is the disparate treatment, and then the use and the failure to investigate and to continue the investigation in a similar manner to the plaintiff. So in that respect, there was disparate treatment, and there was individuals who were treated more favorably, and that weighs into the credibility of their legitimate business reason, which creates factual evidence for a jury to determine. And so the court felt that this case presented triable issues for a jury, and we assert here today that the court was correct in that decision, and we ask this court for the same upholding of that ruling as well. And so I'll reserve the last 2 minutes for any questions.
When did Mr. Cooley notify the department that he was suffering from PTSD?
Yes, February of 2020.
And then this incident happened when?
In May of 2020.
Between February and May, did the department take any action to investigate any of his work, or was there anything that he is trying to argue or he was treated differently between February and May?
No, it was only after the event that happened in May that he was saying, hey, now I'm being targeted for conduct that everybody's kind of using here in the department.
And which conduct is that specifically?
Specifically using racial slurs and derogatory language for individuals of different races. Is there any other questions? All right, well, thank you for your time. That is.
The concept of when an employee is on notice of a potential adverse action doesn't turn on an employee's stubborn refusal to look at the obvious. What the courts tell us is that when the employee is on notice that his rights may have been aggrieved, he has a duty to act, and that the clock starts to run. So if any employee could simply say, well, I didn't really know, the law wouldn't work the way it's supposed to work pursuant to the Supreme Court precedent. But beyond that, I asked Cooley in his deposition, after all these various recommendations, and this is cited in our brief, did you know you were facing termination at that time? And he said yes. It was unquestionable, because he had to sign a document that said if he didn't keep appealing, it would automatically happen. And if he did keep appealing, the sheriff could reverse it. And there's plenty of cases out there, and we cite some of them, where the fact that you're in a grievance and it could be reversed does not toll the clock from running. The clock keeps to run. And Justice Borleo, you touched on this PTSD issue, and I want to shed some light on that as well. A reasonable accommodation request occurs when the employee, and Mr. Hodges is right, there aren't magic words required. But the employee has to go to the employer and say, I need something to change here. Don't tell me what your policies are. I need those to change so that I can do my job. That's the accommodation, is the employer bending its rules. He never asked for that. The only thing he sought was at the 11th hour, when he was about to be fired, he sought FMLA leave. They gave it to him.
Was the intoxication caused by PTSD?
I'm sorry?
Was the intoxication caused by PTSD?
I don't think there's evidence of that at all. There is evidence that when he was closing down the bar, he was drinking while on a pretty strong medication, but I don't think there's any evidentiary connection between the two, Your Honor. Beyond that, they helped him at every turn. That's really important, because no reasonable inference of retaliation can arise when, for example, he tells his boss, I've got PTSD. She says, hey, how can I help? Let's go to the EAP. Let's get you to the Employee Assistance Program, which he concedes. And then he takes a workers' comp, he files a workers' comp claim, which they support him with. And he admits, and it's in our brief, that at every turn they helped him when they realized he was struggling. But we also have a causation issue here, right? PTSD in February, pushing a female officer to the brink of quitting by pushing her and calling her the N-word and committing a crime. He was investigated for 2 policy violations and the crime of assault. And while he wasn't charged, the grievance committee found evidence to support that he had in fact committed that crime. Nobody else compares to any of that. And so that intervening act cuts off any remote attenuated causal link from him telling his boss, I've got PTSD, but not seeking accommodations, and his firing, which happens many months later. As to the issue of similarly situated, I think we've already hit it sufficiently, but one thing warrants mention here, and that is, let's just say hypothetically that there really was evidence that somebody else had actually done something similar, that they had struck somebody while using a racial slur, which is not too far away from a hate crime. If there was evidence of that, what if that person, that comparator, worked in a different department and had a different boss? It wouldn't count. And the reason is because the law recognizes that different supervisors and managers might handle situations differently. So you have to explain that away when you're in Cooley's shoes, and that's if you have comparable evidence. Here, the person he's comparing him to, Sergeant Roy, it was different rank, different division, different boss. One thing that was important about Cooley's job was that he was assigned to a school district extremely racially diverse. And he supervised all kinds of people. They could not have him there. Because Sergeant Roy worked in a different division that might have had an entirely different set of circumstances. And so all of this matters here because, and this is again why this case is particularly important to the county, Cooley is not asking you to apply the law. He's not come right out and say it, but he's asking you to change it. And he's asking you to do that without the evidence to support it and without citation to the cases that this court is duty-bound to consider in assessing these facts. Appreciate the time.
Thank you, counsel. Thank you both for your arguments and your briefing. Cause number 14-23-00109, Galveston County versus Brent Cooley is submitted. We are adjourned and you are excused.